Under the False Claims Act, there's of course a reward system for whistleblowers. And there are really two different levels or two different factors that determine how much of the federal government's ultimate recovery in a case can be given to the whistleblower. The first factor is whether or not the government intervenes. In other words, when the whistleblower files a complaint under seal, the federal government, through the Department of Justice, gets to make the decision on whether they want to get involved or not. In other words, whether they want to take the lead and carry the prosecution of the fraud. If they do decide to do that, then ultimately under the statute, the whistleblower can recover between 15 and 25% of the government's ultimate recovery. If the government decides not to intervene and the whistleblower then decides with their counsel to proceed with the lawsuit themselves, then there's a higher portion of the recovery because obviously the burden on the relator or the whistleblower is a lot greater. And under that scenario, there is generally 25 to 30% of the government's share that can be recovered by the whistleblower. So what are the determining factors that play within both of those ranges in terms of how the whistleblower how their share is going to be determined? And there's actually a series of factors that both the government and the court can look at. And at the end of the day, it really comes down to how much information and how valuable the evidence is that's prepared by the whistleblower. I mean, obviously, it's one thing for a whistleblower to vaguely know about a potential claim and to maybe have only sort of a general sense of the fraud. And then if the government takes that and does all the work investigating the claim and coming up with the evidence that can ultimately prove the case in court, then the whistleblower is going to be entitled to a dramatically lesser amount of the recovery. However, if on the other hand, the whistleblower comes in right at the onset with basically a silver platter with evidence, with inside information that the government would never have been able to find, who maybe is a great witness who can, as an expert in the particular subject matter, whether it's billing or maybe a defense contract, if the whistleblower can come in and be an amazing witness to really help the government put those pieces together. Or for example, sometimes the whistleblower will even assist the government on an ongoing prosecution. For example, sometimes the whistleblower wears a wire, for example. In other words, a recording device where they can go in and capture really good evidence for the government through conversations that they may have with some of the bad actors. Those are the kind of factors that the government's really going to look at and ultimately having to weigh how much did the whistleblower help. In other words, if it's just some vague reporting of the claim without not a whole heck of a lot of evidence, that's going to be definitely at the lower end. If, however, the whistleblower comes in and really gives the whole case to the government on a silver platter and becomes an active partner in bringing information to the government that it can then use in court that the government would not have been able to get on their own, that's the real essence of a meaningfully bigger share of the government's ultimate take. And so it's really sort of a series of factors, and there's various publications that the Department of Justice has put together, and by the way of recommendations. But hopefully at the end of the day, if the whistleblower really comes in with meaningful information that the government could not have otherwise obtained on its own, and then becomes an active partner with the government in prosecuting and pushing the case to a court and, if necessary, to a verdict, then in that kind of situation, the whistleblower is really going to be entitled to a great share of the recovery as a meaningful partner with the Department of Justice.